You referred to us as minors. Can you explain the difference?
With me. Along the expression alone is referred is given to judges and jury who sits on a panel to decide the case.
Are you aware of the gender nature of the virtual? Do you want to recognize that there are female judges here?
Respecting my notes, I plead to know that. With me. My Lord and please, in the next 15 minutes, I shall be addressing this honorable bench with the first two issues of the case, which are 1. Whether the Supreme Court has the original jurisdiction to hear this matter. 2. Whether Articles 35 plus 3 and 38 of Chapter 6 of the 1992 Constitution of Bible are justiciable. The 12 minutes after, my co-counsel shall address this court with the third issue of this case, which is whether the government of Bio's failure to provide quality and adequate educational facilities is a violation of the constitutional rights of senior high school students in Bio. We shall reserve 3 minutes for rebuttals. My Lord, the issue before this court today is the applicant's child education law is alleged that the government's inability to provide quality and adequate educational facilities for senior high school students is a breach of their right to education granted to them under Article 25 violation defined by the Black Law Dictionary 2009 second edition refers to the power and authority given to the court to hear a matter based on first instance or first application by the applicant.
Why should we consider Black's Law Dictionary as an authoritative book?
My Lord, the Black Law Dictionary serves as an authoritative source of definition in legal terms that has been adopted by common law legal system practicing countries.
So under the Constitution of America, are we allowed to recognize what the common law has recognized?
Yes, it's my Lord. Because, my Lord, Article 11 of the 1992 Constitution of Ghana recognizes common law as a source of law in Ghana. My Lord, with your kind permission, I will proceed to advance argument on the first grounds of my first substantive issue. My Lord and ladies, according to the Black Law Dictionary 2009 second edition, jurisdiction is the power and authority given to a court or a judge to make legal decisions and provide remedies based on the facts presented before it in the case. My Lord, in the case of Ghana Bar Association and the Attorney General in Anara 2015-2016, GFR, Supreme Court of Ghana GFR 872, jurisdiction is defined as the power and authority given to a court or a judge to make legal decisions based on the facts of the case, of which lack of which to render any decision taken as now involved. My Lord and ladies, in the case of Kenya versus the Republic, 1968, GFR 548, the court stipulated that the court do not only have the judicial power to make legal decisions in a case, but also to enforce those decisions legally. My Lord and ladies, Article 2+1 of the 1992 Constitution of Ghana states that any person who alleges that any act, an enactment, or an omission is in contravention of any provision of the Constitution may bring an action to the Supreme Court for a declaration to that effect. Article 130+1 of the 1992 Constitution of Ghana also grants the Supreme Court the exclusive original jurisdiction to hear matters of constitutional interpretation or enforcement. My Lord and ladies, it is evident in paragraph 7 and 8 of the fact that the government of Ghana has failed to provide quality and adequate educational facilities for senior high school students in Ghana, which has led to dining hall congestion, dormitory congestion, high teacher-learner ratio, among other challenges.
Because I don't think that's a very blanket statement. Because what I see, or the release I see, okay, before I proceed, let me ask you this. What is the test for assumption of jurisdiction of the Supreme Court? What do you look out for to say that this is an enforcement jurisdiction?
Will be true. My Lord, the court realizes an act or enactment or an omission by the government or any person that is in contravention of any provision in the Constitution of Biafra.
If that's the answer you're given, it means that any case you have can be subsumed under the original jurisdiction of the Supreme Court. Because if, let's say, I fitted and given or stating that a constitutional provision has not been complied with. So that's why the Constitution is very particular about safeguarding the jurisdiction of the Supreme Court and the jurisdiction of High Court in terms of enforcement of human rights provision. So addressing why, let's go to the point, why should we assume jurisdiction over these things?
Will be true. My Lord, the Supreme Court's enforcement jurisdiction can be invoked when the matter in contention, the Supreme Court's original jurisdiction for the enforcement of the rights can be invoked when the matter in contention is of public interest. And this was held in the case of Psalm number 2 with the Attorney General, that when an issue or a matter in contention is brought before the Supreme Court, that is in the interest of the public, the Supreme Court can assume jurisdiction to hear the matter. Also, my Lord, in the case of
cases which fall under public interest? How do you determine cases which fall under public interest?
movement, and indeed, issues of public interest are defined in Chapter 295 of the 1992 Constitution of Biafra as any right or advantage that endures or is intended to endure to benefit the whole population of Biafra. My Lord, it is evident in paragraph 7 and 8 of the fact that the government of Biafra has failed to provide quality and adequate services.
So, talking about invocation of our jurisdiction based on public interest, what is the original jurisdiction of parliamentary cases? Parliamentary cases in terms of elections. Which courts does it go to?
My Lord, parliamentary cases are initiated at the High Court.
Do you know such matters of public interest?
Yes.
So, do you mean that by virtue of it being a matter of public interest, if you bring it to the Supreme Court, we should assume jurisdiction?
My Lord. My Lord, these are not available in my mind.
Then I am telling you that you cannot initiate such in the Supreme Court. By virtue of that, it means that the scope for a matter being of public interest is limited. Something has to be proven before the public interest is attached to it. So, going to the Supreme Court on the basis of public interest will not get you anywhere. It is not one thing to consider. That's why I drove you into a certain point, a certain space, for you to look at the substance of the case. What is the substance of the case? If you can address us on the substance of the case, what you are actually conveying to us, we can determine whether we can invoke our enforcement jurisdiction or not. You may proceed.
My Lord, in Bonfair vs. Virginia 2019, Ghana Supreme Court, the court held that an act or an enactment that is challenged must be proven or that provisions must be specified. It also affirmed this decision in the case of the Gimpa vs. Attorney General. My Lord, the matter in contention here is that the government's action is a clear violation of the right to education granted to senior high school students under Article 35 plus 38 plus 1 of the 1992 Constitution of Biafra.
You do recognize that from the facts, the government did institute free, what was that, free secondary school education.
Yes, Ms. Mary.
So is it your submission that regardless of implementation of that policy, they have still constructed the constitution with respect to the right to education?
Yes, Ms. Mary. My lady, according to the fact of the case, although the free senior high school policy introduced by the government is a good initiative to promote the literacy rate in Baira, it has caused more harm than good, which has led to congestions and even diminished the quality of education senior high school students receive during this time.
So you are saying that the government has reached the rights to education of people in Baira.
Yes,
But I also saying that their implementation of the free teachers policy has done more harm than good. So in your view, they shouldn't have even implemented the free teachers policy. So either way, it's like regardless of their efforts, they have still reached the right to education.
yes, Ms. Mary. My lady, Article 34 of the 1992 Constitution of Baira states that the directive principles of state policy, which Article 35 plus 3 and 38 can be found in it, says that the interpretation of these directive principles of state policy must not infringe on the right of any citizen. And the
What do
students,
you consider as the right to education? What is it?
my lord, most grateful, my lady, right to education is the ability of students in Baira to receive full access to educational facilities.
So in your view, the right to education is synonymous to the right to quality education.
Yes, Ms. Mary.
But the Constitution said right to education.
Yes, Ms. Mary. My lady, right to education must be provided in its full quality to ensure that,
What is quality education to you?
my lord, my lady, quality education can be defined as education that is geared towards the full development of the potential of students. Most grateful.
So, after stating what quality education is, can you clearly apply the facts and draw attention to how the state's actions violate that, and also answer the question of right to education inherently means right to quality education? Draw out what grave human rights violations have been made, because you speak the law, but I'm failing to see you apply to the relevant facts provided.
Most grateful, my lady. My lady, paragraph 7 and 8 of the fact states that the government has failed to provide quality educational facilities. And in this paragraph, you will also see that when Madam Erika Sandima of the Child Education Board visited some of the Sandima Senior High School, Ladipo Senior High School, it is evident that some of the classrooms are without doors, which is a breach of their right to education. Since quality education is also to realize the full potential of the individual that is receiving the education.
I'm sorry, you said some of the classrooms are without
Doors.
How does that affect
My lord,
the ability of the school to provide the avenue for students to reach their full potential? Particularly if you are talking about those.
most useful. Most useful, my lady, the aspect of doors in the classroom is a high skill to face. Because in as much as maybe the students may feel safe themselves, outside this they feel they do whatever they want.
So then it's a threat of their right to life, not their right to education.
My lord, my lady, it's a threat to their right to life and also to their right to education. Because what if maybe something is happening outside the classroom and they will gear their mind towards it?
Don't you think
Don't
you're thinking too far? Right to education, do they have textbooks? Do they have teachers? Do they have doors? What's
My
that?
lord, it's also evident, my lady, it's also evident in paragraph 7 and 8 of the fact that there are high teacher-learner ratios. In hearing,
There's one particular school and the other side.
third subheading of the first heading of our head substantive argument, which is that the government has failed to provide equal educational opportunities, which is in violation of Article 85 of the 1980 Constitution. Your Lordships, the applicant submits that the government has failed to provide equal educational opportunities and facilities, which is provided under Article 25 of the 1990 Constitution of Borough. Article 25 plus 1 subclause provides that all persons shall have the right to equal educational opportunities and facilities, and with a view to achieving the full realization of the said rights, the development of a system of schools with adequate facilities at all levels shall be actively pursued. It is the applicant's humble submission that it is from this provision that the right to education emanates, and as well as the mandate upon the government to ensure the full realization of the said rights. However, considering the facts of the case, specifically in paragraph 5 and paragraph 8, it is clear that the government has not fulfilled this obligation of it. The applicant therefore submits that the government has failed to ensure the realization of the right to education by failing to provide equal educational opportunities and facilities. With the court's time permission, I will proceed to the second subheading of the first heading of our first substantive argument, which is that the government has created educational inequality. We submit that the government has created educational inequality in violation of Article 25(1), Article 35(3), and Article 38(1) of the 1990 Constitution of Borough. The key phrases in all these three provisions are to all, by all, and all persons, indicating an intention by the government, indicating an intention by the Constitution to ensure educational equality. However, from the facts of the case, specifically paragraph 13, the students in Ladiko Senior High School, as well as 10 other schools in the region, that is according to paragraph 11, did not have access to the same educational facilities as other parts of Borough, specifically Zambara, which is the country's capital, and other regional capitals. By failing to provide educational facilities for Ladiko Senior High School and the 10 other schools, the applicant submits that the government has created educational inequality, which is in violation of Article 35(3), Article 25(1), and Article 38(1) of the Constitution. This situation necessitates Supreme Court intervention. My Lords, with the court's permission.
Is it the case that the facilities are not being, or that the facilities are not being maintained by the place?
Most cases, my Lord. From the facts of the case, there are facilities in some of these schools, just that they don't meet the required standards to ensure a good education for the students in the schools.
So the facilities are not being up to the standard.
Yes, please. Most grateful, my Lord. With the court's permission, I will proceed to the second heading of our first substantive argument, which is that the government has failed to meet the required standard of education. Your Lordships, your Ladyship, we humbly submit that the government has failed in its obligation to ensure quality education under Article 25 and Article 38 of the 1990 Constitution. Education is not merely about access, but also about quality. The constitutional guarantees of the country impose an obligation upon the states to make sure education meets acceptable standards. This can be inferred from the purpose and scope of the Education Act. From the purpose and scope of the Education Act, there are particular goals that education seeks to achieve. However, considering the state of facilities at Ladiko Senior High School, as well as the 10 other schools, they will not be effective enough to ensure the full realization of those goals. The Education Act, that is the purpose and scope of that act, states that there should be an establishment of an educational system intended to produce well-balanced individuals with the requisite knowledge, skills, values, aptitudes, and attitudes to become functional and productive citizens for the total development of the democratic advancements of the nation and for related matters. However, the quality of the education has had adverse effects on this, specifically from paragraph 3 and paragraph 4, which indicates a high level of illiteracy within the state. My Lords, in the case of Ghana Bar, in the consolidated case of Ghana Bar Association and others versus Attorney General and others, the court upheld the principle that the constitutional obligations must be interpreted purposely to ensure that rights are not rendered meaningless. Applying this principle, the right to education under Article 25 and Article 38 must be understood to include access to effective and quality learning conditions. However, the situation at Ladiko Senior High School does not merely constitute a failure to provide education, it constitutes a failure to provide meaningful education that meets constitutional requirements, which will further help to achieve the full goals that education.
We are talking about a country that after 67 years of independence continues to grapple with issues of poverty, high literacy rates, among other societal issues. And this country has taken a bold step to introducing this free exercise program. Do you think that on the basis that quality has been compromised in certain parts of the country, the right to education has been violated?
Not grateful, my lord. My lord, the applicants, this is the applicant's submission that yes, the right to education of the students affected and violated.
So you are relying on provisions under the directive principles of state policy. These are objectives or aspirations that the country by wants to achieve. How then do you, reconcile that these are objectives as against enforcing them against the government, not taking into consideration the economic standing of the country to make these provisions? Is it not supposed to be a gradual transition?
Most grateful, my lord. My lord, the applicants, it's the applicant's submission that the directive principles of state policy are presumptively justiciable. There's a presumption that they are justiciable, with certain circumstances in which they may not be presumed justiciable, such as financial conflict, the economic state of the country. However, we are not contending that there's an abundance of resources. We are merely stating that there are certain resources in the country. However, these resources have been concentrated in the regional capitals of the country. So we are seeking for the government to have a widespread distribution of the resources in order for the needs of every region to be met at a particular point where it can progressively continue to another point.
You know the federal case.
Yes, my lord.
So based on the decision of the Supreme Court in the federal case, and based on paragraph 4 of the statement of fact that about 1.2 million age adults were added to the population based on the census that was conducted in 2021. Don't you think it's as a result of this growth in the population that has led to the pressure or compression on these existing facilities? And so the decision in federal, it has to be a gradual transition, taking into consideration the economic might of America.
Most grateful, my lord. My lord, we acknowledge that there's the population has put a strain on the progressiveness of the access to quality education. However, my lord, from the facts of the case, specifically paragraph 13, the reports from the headmaster show that attempts to draw the attention of the higher education service they applied have yielded no result. Therefore, the government is not being proactive to even show indication that they are trying to help improve the quality of the education. That is our submission.
Very well.
Most grateful.
Counsel for Byron, the respondent in this instance matter. With me are my Chantal J.J. for With me are my co-counsels, Emmanuel Osai and Ethel Minahai. I will be addressing this honorable court in the next 10 minutes on the first issue, which is whether the Supreme Court has jurisdiction to hear this matter under its original jurisdiction. My co-counsel will be addressing this honorable court in the next 17 minutes on the second and third issues. If it pleases this honorable court, I will proceed to address my first substantive issue, which is whether the Supreme Court has jurisdiction to hear this matter under its original jurisdiction. I will be advancing this argument under three main grounds. First, the matter which is invoking the original jurisdiction of the Supreme Court is in actual fact a human rights matter. Second, local standard alone cannot be the basis for the court to exercise jurisdiction. And finally, Child Education Watch has not exhausted all available remedies in the lower court. With your kind permission, I will proceed to address my first ground. That is, the matter which is invoking the original jurisdiction of the High Court of the Supreme Court is in actual fact a human rights matter. Jurisdiction has been defined in the case of Ghana Bar Association versus AG and Oman, 1995 to 1996. That is simply the power of the court to hear a matter and determine a cause brought before it, or for which will render any decision taken or order made null and void. In deciding the issue of jurisdiction, matters to take into consideration includes the statute that gives jurisdiction, as well as the true nature of the claim. In an unreported case of Unilever Ghana Limited versus Commissioner General Ghana Revenue Authority, it held that for a court to enforce jurisdiction,
Which court held?
the Supreme Court, it held that for the court to enforce jurisdiction, or for the court to entertain jurisdiction, the subject matter, it has to take into consideration the subject matter, and then if there is no feature of which prevents the court from exercising its jurisdiction. The issue for discussion here, my lord, is whether the applicant, per paragraph 16 of the fact, is seeking a constitutional interpretation or enforcement justifying the original jurisdiction of the High Court, or merely seeks an enforcement of the fundamental human right of the children of Barra. In Yard of the First versus Amelia 1981, 1 GL report 3, it was established that regardless of the manner in which a matter is closed, the real issue that arises is from the writ, which is from Article 2 and 130 are not or does not issue the exclusive jurisdiction of the Supreme Court, then the Supreme Court will decline jurisdiction. The applicant per paragraph 15 of the fact claims a violation of the student's right to education and the government's duty under Articles 35 and 38 of the Constitution. Per Article 142 of the Constitution, the High Court can enforce these rights. My lord, in Republic versus Special Prosecutor, in Republic versus Special Tribunal.
The High Court can enforce these rights.
Yes, ma'am.
So it is not in doubt that the High Court has a jurisdiction to enforce fundamental human rights.
Yes, ma'am.
The issue is who has lodged this complaint, who has approached the court. So the issue of who plays a victim in the case is of paramount interest. It's not just about human rights enforcement. Under Article 33 of the Constitution of the right complained of has to come directly or indirectly to the person who is making that complaint. So in this case, do you still maintain that the plaintiff or the applicant in this matter is directly affected, for which reason this matter ought to have been brought under Article 33 and not by invoking our original jurisdiction?
Most obliged. My lord, in answering this question, I will avert the court's mind to my second argument. That is, the local standard alone cannot be the legal basis for the Supreme Court to hear jurisdiction. A careful observation of our jurisprudence reveals the Supreme Court's dealing in matters before it. Two things. The court takes into consideration the local standard, that is the person's capacity, and then also the subject matter. In 24 versus Attorney General 1980, GL Report 637, the court considered the plaintiff had standing on the basis to bring an action to the Supreme Court because of the nature and then how it fell under the purview of the Supreme Court. Although the person did not have, that is the J.M. that is to fall did not have a legal or personal interest in the matter. Also, looking at the SIBA case, that is the MPP versus Attorney General, the SIBA case, the court argued that the MPP was deemed to be a legal person, and therefore it did not matter whether they have public interest, but then the personal, they were deemed to be a legal person. However, in Edusei versus Attorney General, the court emphasized that the plaintiff had standing. However, it lacked the court's jurisdiction to hear the matter because of the nature in which the issue or the subject matter was holding. This takes us to the case of Yadom versus Amidiampo, where the court held that regardless of the manner in which a matter is holding, the real issue arises from is the risk that was invoked. And paragraph 16 of the facts, it says that the applicant is seeking for an enforcement. The applicant is seeking for a violation of the applicant is seeking for an enforcement of the violation of the people's right, that is the children's right to education.
No, so the same paragraph 16 is very instructive. Under Article 2, Article 1 of the Bar Constitution, the text alleges that there has been anything that has been done, whether an act or omission, is in contravention with any provision of the Constitution. The person has the right to access this court invoking our original jurisdiction. Under the same paragraph 16, there's an allegation by the plaintiffs that the failure to provide adequate and proper educational facilities for the students of senior high schools is in violation of their right to education. It goes further to ask for a declaration that the government is in breach of Articles 38 and 35 of the Constitution of Ghana. Don't you think they are in line with what Article 2 and 1 of the Ghana Constitution requires? That if you are alleged there is a violation of any provision of the Constitution, you can access this court. They have demonstrated that indeed there is a violation, and these constitutional provisions are in attack. And so we call on us to intervene.
Not only that, my Lord, it is in fact true that the applicant is claiming for a violation of the children's right to education. However, Article 33 has made it emphatically clear it should be in relation to him. And Article 140 is also stating that the High Court will have jurisdiction to hear matters in relation to fundamental human rights. However, under Article 2.1 of the Bahrain Constitution, it also alleges that a person who alleges an enactment or an omission is in contravention with the provision of the Constitution, it may bring an action to the Supreme Court. However, our argument, we the respondents, we argue that the subject matter in which they are seeking for the Supreme Court to enforce they are seeking for the jurisdiction of the Supreme Court. It's not an issue for the Supreme Court to do, because in.
So is it your argument that once it borders on human rights, then our original jurisdiction cannot be invoked?
Your original jurisdiction can be invoked per Article 131 of the Constitution, which says that subject to the provisions under Article 33, the Supreme Court will have jurisdiction to enforce and interpret the Constitution. However, the subject to does not mean a person who alleges a violation of their fundamental human rights manifests it and goes to the Supreme Court to seek an enforcement of their fundamental human rights. There are hierarchical the Constitution has set out hierarchy where the Supreme Court deals with enforcement or interpretation aspect, and then the High Court deals with the fundamental human aspect. So we are arguing that the applicant's claim is solely a human rights violation, though they may have standing in the Supreme Court. But the subject matter which is brought before this court is not the appropriate one.
Under no circumstances can a person go before the Supreme Court
where a person had gone to the Supreme Court to seek for an enforcement of their fundamental human, as it was held in the Gimpa versus and then so for versus Attorney General. However, the court looked at the public interest. Per the facts provided, it is not evident that child education has any relation to the children of Bara. Therefore, we submit that they do not have the locus. They may have the locus to stand before the Supreme Court, but the subject matter which they are invoking, the original jurisdiction of the Supreme Court, is not.
So to make it clear, they don't have the locus before the Supreme Court because that is where I don't get, because they are
Because of the subject matter, which is in relation
but then
to
they are not
the
directly affected by whatever is going on in the
Yes.
education sector. That's what I'm saying.
So we are seeing this not the public.
They have closed the suit to make it look as to seek enforcement from this honorable court. But however, in actual sense, it is a human right violation which has to go to the High Court. My lords, I have been noted that my time is up. I will seek 1 minute to summarize my points. My lords, we argue that to stretch jurisdiction is to seduce the law, and that respectfully is a dangerous affair. With your kind permission, I will cede the floor to my co-counsel, Emmanuel Inside, who will address this point on the second English.
Thank you for time to get us in this discussion. Very well.
As the president, bar others from accepting their rights on those provisions, even on a set of different facts. My lords, will now be a position for the court to take.
My lords, we accept that it may seem to bar others from enforcing.
No, it is going to bar others. This court is a court of record and a court of final decision. If we take that decision, it's binding on all other courts and all other persons having involved in the law. So that makes your submission problematic, that those two provisions are not justiciable, and you are urging these courts to accept sin.
My lords, the provision specifically states that Article 38, that educational facilities are to be provided, quote unquote, to the greatest extent feasible. And also at clause 3, it is provided that depending or subject to, quote unquote, the availability of resources. We submit that due to the particular framing of the provision in this way, it is to the effect that those provisions are dependent on policies and are dependent on the government's capability. To make the provisions justiciable means that we are compelling the government to at all costs carry out those provisions. However,
and to make it not justiciable also means that we are helping the government to share this responsibility, even when it is at the point where it has the resources to enforce. I think that's why the current position of the law is that it's presumably justiciable. What we are trying to get out of you is, with the facts before you and your claim of non-justiciability, what exactly is your position? I'm not sure if my colleagues have been able to use that yet.
my lords, I've been elected at my times.
Very well. You have a second respondent, right? You do have a second respondent. Just one respondent. So
So we have two respondents, so it's just the council and the co-council.
yes, so your co-counsel will be here. Yes, we want to make use of the time. We are going to bring you. We'll take it on with your co-counsel. So issue 3 is pending, right? Issue 3 is pending. So we'll get back to it.
What could
exclusive original jurisdiction to
And then we are asking you that it doesn't mean that the Supreme Court can never have jurisdiction over human rights claims.
respectfully we can't.
Under what circumstances does the Supreme Court have jurisdiction?
My lady, in the case of the Catholic Free Special Tribunal ex parte accusa, the court outlined the criteria for invoking this honorable court's jurisdiction, which requires where there is ambiguity, where there is a conflict, and when there is a requirement of legal substantive interpretation. However, Article 25 of the 1992 Constitution is clear and unambiguous.
Where there is a conflict, what do you understand or where there is a conflict?
Where there is a misunderstanding.
Could you also say that that conflict translates into non-compliance because when an action does not correspond with the constitutional requirement, the conflict arises? And that if you concede that that conflict can arise, the applicants are saying that there is a conflict between the actions of the state and the constitutional requirements to provide equality or equal access to educational facilities and whatnot. Why are you saying, still holding on, based on the same authority provided, why are you still saying that the Supreme Court doesn't have jurisdiction when they have clearly shown you that there is a conflict? Based on your own authority.
Respectfully, there is no conflict with this situation in this matter.
Okay. Can you explain how or what did you say there is no conflict between the actions of the state and their constitutional obligations?
My lady, per paragraph 5 of the fact, the barrier is a developing, per paragraph 1 of the fact, barrier is a developing country. And pursuant to paragraph 5.2, it is evidence that barrier is progressively helping the state by instituting educational facilities to them. However, go ahead.
Counsel, you left us answer.
Please, could you clarify the question?
What did you understand by the initial question you were answering? You said there is no conflict. I'm asking you to prove that there is no conflict. And you say by the developing
The
country.
respondent submits that there is no breach of any constitutional provision by the state's actions
Because
because, per paragraph 5 of the fact, it is evidence that Maria is still exercising their right as a state to provide educational facilities to the students in Maria.
does that justify why some people need to be excluded from that progressive initiative?
My lady, the implementation of the free senior high school allows access to education.
That's all. I'm not sure you understand the position of the applicant, do you? You understand their position. What is their position?
The content that this was jurisdiction is
Right, and you have to pass jurisdiction. You are saying that there's no conflict between the actions of the state and the constitutional obligation. Why? Because by the developing country and that they are still pursuing educational aspects. And your applicants are saying you are excluding people in that so-called progressive initiative. You say it is justified. I'm trying to understand on what basis do you say that that exclusion is justified and hence there's no conflict.
My lady, the respondent submits that in paragraph 1 and 3 of the agreement, Bayer is facing serious financial challenges, relying heavily on export of unpossessed natural resources. The government itself has acknowledged that it cannot fully meet its obligations without private support. This shows that the inability to provide adequate educational facilities is not a form of neglect, but from genuine financial limitations. What's your two? I shall proceed to our second substantive argument, which is Article 35 and 38 are presumptively justiciable and
subject to certain constraints. My lords and my lady, the respondents respectfully submit that Article 35(3) and 38 of the Directive Principles of State Policy, although presumptively justiciable as held in the Ghana Lotto Association case, the National Lottery Authority, are not justiciable in this present case due to the constraints. Respectfully, my lady, in the case of Ghana Lotto Operators Association, the National Lottery Authority, the plaintiff, private lotto operators, challenged the National Lotto Act 2006, which established the National Lottery Authority and prohibited private lotto operation. They claimed that the act violated their constitutional right to free economic activity and the role of their private sector. As established earlier, Bayer is facing serious financial challenges per paragraph 1 and 3 of the Act. Also, paragraph 5 makes it clear that the state has not abandoned its responsibility to promote education. The implementation of policies such as the Free Senior High School initiative shows that the government is making progressive efforts to fulfill these constitutional duties. Given these circumstances, the respondents respectfully urge this honorable court to decline jurisdiction because there is no clear constitutional breach that requires judicial intervention. If you may please the court, I shall proceed to our second heading of our second substantive issue.
Article 38 of the Constitution, what does it say?
Respectfully. If you may permit the court to refrain. My lady, Article 38 of the 1992 Constitution states that the state shall provide educational facilities at all levels and in all the regions of Ghana and shall, to the greatest extent feasible, make those facilities available to all citizens.
So do you think the state of Ghana has complied with this provision?
Respectively so.
How?
That is the respondent's submission that the provisions under the Directive Principles of State Policy found in Chapter 6 of the Constitution are not justiciable in this present.
But they're supposed to guide you. So if you are on your own tangent, you are not being guided by this, have you complied with it or not?
Respectfully, it is the respondent's submission that Bayer is complying with the provisions of the Constitution, which is Article 38.
So how so?
As stated earlier, per paragraph 5 of the fact, it makes it clear that the state has not abandoned its responsibility to promote education. The implementation of policies such as the Free Senior High School shows the government is making progressive efforts.
The state shall provide educational facilities. What does educational facilities mean to you?
Educational facilities include schools, adequate facilities,
Adequate facilities, adequate what? What's the facility?
adequate chairs, tables, qualified teachers.
So they are saying that the state has complied with this.
My lady, due to the financial constraints in Bayer, it is the respondent's submission that Bayer as a developing country is still trying to comply with this provision in the Constitution.
So you mean that you have not fully complied, you are in the process of complying.
Respectfully, sir.
But then you seem to say that there's no violation because clearly some people are being left out of that. And you keep referring to your commitment to providing facilities, the evidence of your commitment being free education. However, the facts provide that the private individuals who have consistently provided these educational facilities same to your state through the free education policy as a public without showing any real investment in it. So why is that progressive compliance that you keep speaking of? Why in the fact do you say that? Because on one end you say you have complied, on the other end you say that you are under no obligation to comply because you are facing financial difficulties.
The respondent's submission that Bayer is complying complying with Article 38 of the 1992 Constitution. However, this is being limited by their financial constraints.
So, you are being asked how to say they are complying. If, like nothing, you're not stating anything in the fact that suggests that you have built 10 number of schools and that you are progressing to building this number or you are providing this facility. Yet you keep saying you are complying. The only thing that you make reference to is the PSHS policy, which is actually the problem that the applicants contend that it has caused congestion. It has provided inhumane circumstances in which students are not there. And so, how are you complying? Where in the facts do you refer to make draw attention that there's some kind of commitment from the state?
Respectfully, I have not updated my mind.
Then the applicants will have a basis for saying that you're not complying, because you can't prove that you're complying. You just expect the court to take your word for it that the state is complying.
Respectfully, paragraph 7 of the fact, if the respondent still contends that the implementation of the free SHS policy in Barrier has been established and they are trying to comply with the provision in Article 38.
So you're trying to comply.
They are not, but due to financial constraints, and since Barrier is a developing country, that's the reason why they are not able to raise funds.
So you are not, you are complying in parts. In parts.
Okay, you make reference to paragraph 7 of the fact, stating that there's some commitment from the state. Your statement is that the free SHS policy has been instituted and that you are complying. That was your initial statement.
But the respondents submit that, despite the fact that the free SHS has challenges like the increase in student enrollment and classroom
Okay, you misled the court when you said paragraph 7 demonstrates the state's commitment.
Respectfully.
But then the body says what the challenges of the free SHS policies are, which you are now coming to read to me, which is still drawing our attention that the applicants still have basis to say that you are not complying by a constitutional requirement of providing access to all regions, not specific regions to the neglected others. So how do you still find justification for your actions?
Respectfully, I was directed the panel to the room. But the respondent submits that per paragraph 5 of the fact, various educational facilities show significant progress in terms of access.
Access does not equate facility. They are saying that you have given access to everyone to come into the school, but you have not given them the facilities they need to excel in the school. So yes, they have given access. That's not being consented because now numerous people have entered the school, but then the facilities are not there to accommodate them. That's the basis of the applicant statement. What's your response to that?
My lady, the respondent submits that despite the challenges of the free senior high school, pursuant to paragraph 7 of the fact, such as inadequate teaching and learning materials, postal infrastructure, it still shows that the respondents Barrier has provided to some extent, facilities to the children in Barrier.
You mentioned that the directive principle of state policy, they are presumptively, what does that mean?
Respectfully, the respondents submitted that Article 35A and 38, which forms part of the directive of state policy.
What does it mean? Like, what should we look for? Presumptively justiciable, but what does it mean?
That it can be reverted. That case to case.
So, considering the facts of the case, and also considering your failure to prove that you have complied with Article 38,
The respondents submit that the presumption of justiciability is rebutted in this instant case due to financial constraints.
So you're arguing for the
basis for rebutting presumption. If you know you can't, you don't have the money, why then do you need education?
My lord, Rwanda is a developing country.
I get that. It's a developing country, meaning education is progressive. But if you know you cannot accommodate or provide the requisite infrastructure for schools, why then do you open education to all? The Constitution says access to education, everyone must have access to education. But if you know you don't have the money to do that, why then do you open it up? So in that cases, you've created or you've opened the floodgate for everyone to have access to education, but you're not providing the infrastructure. Once you make such a plan, there should be something to take care of the infrastructure, and you're not doing it, so that's a non-compliance. Unless there is something more to convince us that, yes, you provided infrastructure and you're not utilizing it, we don't see how we should take that presumption of it. So to us, it will be justiciable. Do you agree with me? Okay, then convince me. Yes, summarize it.
The respondents submit one thinking that Article 35 and 38 of the Constitution are presumptively justiciable in this instance case. My lord, it is the applicant's
You're
argument.
summarizing your argument. Yes, summarize the point.
My lord, the respondents will see by their fact that due to the financial constraints in Ghana, the justiciability of these provisions are rebutted in this instance case. I shall leave the floor to my learned co-counsel to address this cause on our first substantive argument. Respectfully submitted, counsel for the respondents. My lord, your lady, if it pleases this honorable court, my name is Isha Ababanko, co-counsel for the respondents in this matter, representing the Attorney General, the Ministry of Education, and the Higher Education Service. In the next 10 minutes, I'll be addressing this honorable court on the third issue.
why is the Attorney General a party to this case?
Thank you for the question. The Attorney General is a party to this case because the Ministry of Education is the body ministry, and it is under the government body, specifically the executive arm of government, and the Attorney General is the lawyer of the state.
What's your authority?
I don't have anything to add, but this is general knowledge.
The honorable court is asking for your capacity. They are asking you to justify why Attorney General and uninterested party is standing before the court, and your response is that it's general knowledge.
No, I apologize for that. The Attorney General is standing as a party because it is representing the body of the government, basically the Ministry of Education for the country.
So there's a constitutional provision, or there should be a constitutional basis for the Attorney General representing the Ministry of Education and the government.
Do you know it, or you're now going to go through the Constitution to find it?
No,
I'll be addressing this issue under two headings, which are the obligation to provide educational facilities is subject to resource limitation, and the provision of educational facilities is a progressive right and not an immediate obligation. With the court's permission, I will start with my first argument. The obligation to provide educational facilities is subject to resource limitation. Under Article 38(1) of the Constitution, it shall be provided to the greatest extent feasible, which reflects the practical limitations faced by the state in fulfilling its educational mandate.
Can you read that sentence, please?
The state shall provide educational facilities at all levels and in all regions of Ghana, and shall to the greatest extent feasible make those facilities available to all citizens. The inclusion of feasible in the constitutional provision recognizes that the state duty to provide educational facilities is limited by practical and economic realities. In Federation of State Associations versus Public Universities of Ghana, the court acknowledged that the right to education is not merely violated because of disparity in the quality of facilities across the states. The state is not required to provide identical educational facilities, but must demonstrate a genuine effort to improve the access and quality of education across the states.
Oh, okay, so in other words, the state can decide to discriminate you and decide that in Zambara, the capital, the rich kids should have the good schools and the Limpopo people should be studying without facilities. That's your solution.
No, respectfully, no. What I'm trying to say is that the state is not obligated, okay, the state is obligated to provide educational facilities, but it has to provide them, it's a progressive right, and it has to provide it through with the availability of resources that it has.
But the state have enough resources to select specific regions to educate others.
No, it doesn't. By looking at the status of the state, Ghana is a developing country with a population of up to about 35 million people, and it has its illiterate population at 7.9% below the age of 6 years. And in the year of 2010 and 2021,
So the fact that you're stating, they don't seem relevant to the question. Is the state allowed to be selective with how they enforce fundamental rights?
no, it doesn't.
So but what did the state do in the past?
Yes, according to the fact, the state provided facilities for schools in the capital regions of the country.
So what did they do in Limpopo? What did they do in Limpopo?
And they did not provide those facilities.
So you have breached the fundamental rights of the people in Limpopo.
Yes, we have, but then
So what are you doing?
we have not necessarily breached the rights of the people. It's the state, per paragraph 30.
How, what are you doing?
I want to put that looking at the situation of the state and knowing that the capital cities of every region has more people as compared to those of the rural areas, it is reasonable to provide educational facilities starting from those areas before coming to the rural parts of the country.
So what's the test of disability?
I've not
So it's reasonable to you. So then convince us that it's reasonable because since you don't have the universal test for disability,
It is reasonable because looking at the level of literacy in the country, it wasn't stated in the fact that most of them are in the capital state. However, it is common that most people reside in the capital state because of infrastructure, education, being closer to the government and
is this from your general?
Disagree with you. In every state, most educators are found in the rural sector. So education should start in the rural sector. So the fact that you're starting in the capital region seems discriminatory to me. And they've come on the tangent of the directive principles. We can hinge that on the right to discrimination, but not to discriminate against, sorry. And we will find whatever we need to be brought justiciable. So you are not convincing us. You are rather advancing arguments for us to be persuaded in our minds that you are discriminating. to argue or try to make points to convince us why those acts are not discriminatory.
Thank you very much. Your Excellency. Okay, sorry. Your Lordship. The right to education is a progressive right, which means that it's supposed to be realized over time and according to the available resources the state has.
What's your authority for stating that the right to education is progressive?
Under the International Covenant on Economic, Social, and Cultural Rights, it constitutes right to education
Are
as
we bound as a state of Nigeria to adhere to that covenant?
Your Excellency, we are according to paragraph 2 of the Act. It states that the Biola education as ratified all international conventions which it is subject to as part of its laws, including the International Covenant on Economic, Social, and Cultural Rights. And under Articles 13 and 14 of the International Covenant on Economic, Social, and Cultural Rights, it provides for education.
So, between the constitutional obligation or the constitutional obligation stated and what the covenant is saying, which one takes precedence?
What the Constitution says. And under Article 13 of the ICSPA has been explicitly provided for in Article 38 of the 1990.
What does that?
And it states that the state shall provide educational facilities at all levels and in all regions of Ghana and shall to the greatest extent feasible make those facilities available to all citizens.
So, in this context, right, you are telling us that it's supposed to be progressive. And you're relying on Article 38 to say that it's supposed to be progressive. Applicants are saying that it's supposed to be in all regions. So even if you are arguing progressiveness, we should see it at some merit in every region. But certain regions are being left out of this progressive initiative. What is the basis for that discriminatory selection? Why do you prioritize certain regions over the other? That question has still not been answered. The court keeps asking.
It is not the intention of the government to prioritize some regions over others, but then Ghana is a developing country and it has very limited resources. Its main source of revenue is through the
Development as if it's not the attack, so we like to rephrase.
It is our contention that this statement was made by one Mr. Adams, and it has not been confirmed that indeed that is the situation in the country. It was just a statement. We don't know for sure that the government prioritizes providing educational facilities in some parts of the country while leaving others. What we know is that the rural areas of the country do not have educational facilities, but we didn't explicitly state that only the regional capitals in the country have educational facilities.
Have you enjoyed selecting part of the fact that not to your benefit and ignore the others and say that, well, somebody statement we should ignore it. But you are not given an alternative to show the state's commitment to providing infrastructure to all people, regardless of where they come from. So we will still stick with the fact as what is true, and we will still require that you give us justification on why that has happened.
Thank you very much. Your leadership. The right to education comes in two folds: accessibility and then the quality of it. The accessibility has been provided by the state through the implementation of the free senior license, and this is seen across all of the schools. All of the schools in the country. However, it's left with the qualityness for the state to realize, and this is subject to the resources of the state, which the country at this present time does not have. But in due time, the government will be
be able to realize this quality by providing the infrastructure that the other schools in rural areas need. But as at this time, the country does not have the resources to do this.
Okay, so you are agreeing with the applicants. You said, let me see. You said that the right to education comes in two groups. So access to education, quality education. So in your view, the right to education is equal to the right to quality education. So on that basis, you agree with the applicants that you have reached the right to education because you provided only access and no quality.
You contend that yes, we have provided the accessibility that is needed, and we are still working on the quality of it. They are still working on providing
So
the
your first respondent said you are in the process of complying. I asked, and I'm asking you again, what is the evidence to suggest that you are in the process of complying?
From the statement of facts, it wasn't proven anywhere that the government is taking some actions with respect to.
And the applicants have basis because clearly there's no evidence that you are committed to ensuring that access to infrastructure.
The leadership, there's in fact evidence to the accessibility that our government has provided
Because it's the problem. The PSHS problem is the problem that the applicants say because I hope the party more people are treated with. There's no commitment from the government to ensure that people have quality education. And I think the right to education is a two-tier test. You have succeeded in complying with one part and you have eliminated the other, which means that you are not complying. Would you say that applicants have basis now?
No. Looking at the facts, the illiteracy rate in the country is almost half of the total population of the country. So if the government did not implement this policy, in years to come, we won't have people in the government sector.
The PSHS policy defeats the purpose for which it was instituted if it's supposed to resolve the illiteracy rate and then people are in schools and are not doing well. So they are still illiterate for the lack of a better description in the schools. So technically you haven't really done anything.
The leadership, there was no part of the fact stated that school children in the schools after the implementation of the PCIs are not doing well.
Paragraph 5 makes mention of co-educational accounts, if I'm not mistaken. Second in paragraph 5, the environment severely impact both teaching and learning processes, ultimately affecting the students' academic performance. So if you are solving the issues of illiteracy and the lack of infrastructure is also resulting in poor academic performance, which ripple effect is still the illiteracy rate, how then do we say that the PSHS policy does not violate the right to education? Because clearly, that's what's happening. You can answer that question and then make a concluding remark and you're correct.
Okay, thank you very much for your question. The PSHS policy is still providing for the educational. The government implementing the PSHS policy has implemented is fulfilling its obligation under the Constitution to ensure that all students across the board have access to education. However, the quality of the education is not being met. And yes, it has affected the results of the education and then the outcome of the academic work. But then it does not violate or it does not go against the government making it available and accessible. And I think that is what this honorable court should really look at. In conclusion, the respondent submits that the government did not reach its obligation by not providing quality educational facilities to school children in senior high schools. And we humbly pray that this honorable court finds that it is not the proper forum to hear this matter, and therefore lacks jurisdiction in this instance matter. And also Articles 35(3) and 38 of the 1992 Constitution
my lords and ladies, the applicant has 3 points for rebuttal. 1. The Supreme Court has communal jurisdiction to hear this matter. 2. The right to education under Article 25 clause 1 are subject to availability of resources. 3. The government has not made any effort to address the issue of inadequate education. My lords and ladies, in the case of Sam Matu with the Attorney General, 2000, Supreme Court of Ghana Law Report 305, the Supreme Court stated the distinction between Article 33(1) and 2 clause 1, stating that in Article 33(1), where a person will invoke the jurisdiction of the High Court, that person should have a personal interest in the matter. My lord and ladies, in this instant case, child education was the applicant does not have personal interest in this case. The applicant is coming for the enforcement of the right to education of senior high school students in Baira. Also in the case of Ezeamu, the Accra Metropolitan Assembly and another, 2007-2008, Supreme Court of Ghana Law Report 611. The Supreme Court enforced the right to dignity, not to the interest of the plaintiff, but of others. My lord and ladies, the right to education under Article 25 clause 1 is subject to availability of resources. As enshrined in Article 38 clause 3 of the 1992 Constitution of Ghana. The applicant hereby realized that the government's inability to provide inadequate facilities undermines the right to education granted to senior high school students under Article 25 clause 1c, which states that education shall be accessible to all based on the basis of capacity. Also,
isn't education accessible to all? From the fact, doesn't everyone have access to education?
Respectfully to my lord, but my lord, they are not realizing the full rigors of the education.
Yes, I understand that, but for this particular point as a matter, I can't quite problematic because you are arguing that capacity should be linked to access. They are saying they don't have capacity and they've created access. So why would you miss the point on that? I think your particular point is in relation to infrastructure. And they are saying it's a twofold thing, quality and then access. So if access has been realized, if you raise a rebuttal on that, I think you should shooting yourself in the foot. Because it would mean that they actually have complied with the constitutional provision.
Respectfully to my lord, however, the full realization of education moves with capacity and also the quality of the education being offered to the senior high school students. Hence, the government has granted access to students to have senior high school education for free, but it has failed to provide the capacity and the infrastructure to accommodate these students.
But the government from the fact, does it have the capacity to provide infrastructure?
My lord, according to paragraph 3 of the fact, states that viral is an abject poverty. However, the government has enabled access to free senior high school education. Hence, the government.
I like that point you raised. By saying that they've given access to free senior high school education, it means that the government is trying, that's why they don't have the money, right?
Yes, my lord.
You agree with that?
Yes,
So
my lord.
if they've made access available to everyone, and you agree with me that they don't have money, you should know that it will take time for infrastructure to come into place. So they are not, it's not a deliberate non-compliance. They can't do it.
My lord, however, the government is fully aware of Article 25 clause 1, 35 clause 3, and 38 clause 1 of the 1992.
What does 35 clause 1 say?
My lord, if you kindly permit me.
So,
Article 25 clause, all persons shall have the right to equal educational opportunities and facilities with the view of achieving the full realization of that right is the basic education shall be free, compulsory, and available to all. Secondary education in its form, including technical and vocational education, shall be generally available and accessible to all by every appropriate means, but in particular by progressive introduction of free education.
So we are talking about senior high schools.
Yes.
Read the last part. Yes.
Secondary education, all persons shall have the right to equal educational rights and facilities with the view of achieving the full realization of that right. Basic education shall be free, compulsory, and available to all. A. B. Education. Secondary education in its form, including technical and vocational education, shall be generally available and accessible to all by
To all. So it doesn't mean they should even have access to free education. There's some kind of a cap there. It means if you have the ability, let it work. They have made it work. The only thing they are not making work is the infrastructure.
The government has failed to provide quality education. Although they have done
No,
this.
listen, the quality education you are talking about, I don't see it there. We are saying that you should have access to the education there. Yes, by that provision we can infer quality. But even that provision is limiting in itself because it's telling you that as appropriate, you let everyone have access to it. Meaning you can deny certain people that they have given that rights to everyone.
My lord, the 25 plus 1 states that this by every means applicable. The government has demonstrated that it brings access to all senior high school students. However, it has failed to realize that the accessibility should come with the full realization of the quality education. Here we provide adequate facilities and educational resources to accommodate all the students they intended to care for under the free education policy.
But you agree that provision also deals with time.
Yes.
Okay, that's it.
I'm Mr. Good.
It is the respondent's contention that the matter before this court is a matter of jurisdiction and not personal capacity. And
The matters are quite like a big argument, like a big arguing the points. Very correct.
by your lord, my name is. The applicants are arguing that they do not have personal interest in the matter. Hence, this court should uphold jurisdiction. However, it is the respondent's submission that personal capacity is not the main factor, the main issue in contention, but rather the lack of jurisdiction, because the right to education gives the High Court the exclusive original jurisdiction to
So
it.
they argue the lack of personal interest as basis for the Supreme Court arguing jurisdiction. That's why it's like at the High Court. So it's still on the matter of jurisdiction. You are saying that the issue in contention is jurisdiction and that they argue personal interest, which is not, has no bearing on jurisdiction. But the court is drawing attention to the fact that it's still on the basis of jurisdiction.
My lady, the respondent submits that, pursuant to the case of the Public Peace Special Tribunal, invoking this court jurisdiction, the case outlined the criteria for invoking this court jurisdiction, which includes whether there is ambiguity, or there's a conflict, or there's a legal substantive interpretation.
You stated that was correct.
Yes.
But
Yes.
we are not talking about the capacity of the person coming before the court. Article 33 states that a person who is coming before the High Court must be someone who is personally affected by that. With the Supreme Court, you don't need to be personally affected by it. Anyone can come once it's in the public interest. And that is the argument they have made.
So it's still on jurisdiction because there's a linkage between the personal capacity and public interest. That's what we need to address us.
My lady, the respondent submits that under Article 33(1), the plaintiff should be directed to that forum to address this matter before, despite the fact that they have no personal interest in that Eastern case. It does not guarantee the High Court to grant them a remedy.
I don't think that. I mean, they are anyone. They have come under Article 2(1), Article 130, right? They are bringing a matter which is of public interest, that the general free education policy you set up is a breach of, or the lack of infrastructure is a breach of the constitutional rights, constitutional rights. And you are saying that they should go to the High Court on that basis. These are persons who don't have a personal interest in that matter. They are just an organization spearheading education. So in our opinion, they are right before the court because they have the right capacity. But if you are saying because the matter is of a general nature, they should take, or a human rights nature, they should take it to the High Court, I find that a bit problematic.
My lord, the respondent submits that there is no clear constitutional breach which requires the plaintiff to bring this matter before the tribunal.
So you do agree that they have capacity as a body corporate who is interested in enforcing a matter of public interest. However, there is no issue of non-compliance. Well, we proceed with the submission. It's time to vote now.
Discussing something. The Supreme Court of Barrier is now adjourned. Counsel and spectators, please clear the courtroom to allow the judges to report. Thank